After conducting HR audits on hundreds of small businesses for the past 15 years, I want to share the top employee legal compliance concerns we see most often. Number 3 on this list is the most expensive, and number 5 is the one that can do the most damage to the reputation of the organization, both internally and externally. I'm going to jump right into them, but really, really quick. If you are leading a small business, a 1 to 500 headcount in any capacity, and the people stuff feels like a lot, hit that subscribe button so we can figure it out together. Okay, here we go. These are the 5 things I see most often. None of them are exotic. All of them are preventable, and at least one of them is probably happening in your small business right now. Mistake number 1 is documentation gaps. I know that this has become somewhat of a dirty word in HR, a roll your eyes moment, because if you are a leader who has ever gone to HR and wanted to discipline someone, terminate someone, hire someone, or give someone a raise, they have likely told you to document it. Somewhat of a joke, right? But what that eye roll tells me is that you have never sat in a deposition and had an attorney question your intent. Because the absence of documented proof in employment law is almost always evidence. When a business ends up in front of an administrative agency or a plaintiff's attorney, the first thing that gets requested is documentation. Performance records, written warnings, notes from conversations where expectations were set, offer letters, signed policy acknowledgments, the list goes on. Anything that shows a decision was made intentionally based on documented behavior, not arbitrarily, or worse, based on protected reasons like race or gender. Memory is not a defense. Recalling conversations is not a defense. It's a he said, she said that a plaintiff's attorney will dismantle in a deposition in about 15 minutes, and they will do so brutally. Documentation doesn't have to be elaborate. A brief written record of a performance conversation, a written warning that was signed, an email confirming what was discussed. What it has to be is consistent and contemporaneous, written at the time, not reconstructed later. Your intent will come into question almost every single time. The small businesses I have seen lose big are not the ones who made a bad decision. They're the ones who made a reasonable decision and couldn't prove it through their documentation. If a decision you made about an employee ever gets challenged, the only thing that matters is what's written down. Mistake number 2 is leave of absence mishandling. The second one here surprises more small business leaders when we do an audit than almost anything else on the list because they typically don't know that these obligations even exist. So an employee comes to you, they have a medical situation, maybe they're having a surgery or a mental health crisis, a pregnancy complication, something, a family member who needs care. It's very easy to handle that as a people conversation. You want to be flexible, you want to support your employee, so you work something out informally and move forward. What you may not realize is that depending on your headcount, your state, and the nature of the situation, you have just entered federal and state leave law territory. The Family and Medical Leave Act applies at 50 employees, but many states have their own leave laws that kick in way earlier than that, sometimes at 5 employees. And those laws come with very specific obligations like written notice requirements, reinstatement rights, documentation you're required to provide and retain. There's specific timelines you're required to follow. The informal accommodation, the one that felt kind and flexible, may have also been non-compliant. And if that employee later feels they were treated unfairly, that informal handling becomes Exhibit A. There's also a second layer to leaves that no one ever thinks about, and that's the intersection of leave and accommodation. When an employee's leave request involves a physical or mental health condition, the Americans with Disabilities Act may also be in play, and that triggers an entirely separate interactive process that has its own legal requirements. These two bodies of law overlap in ways that are genuinely complicated, and getting it wrong carries massive liability. The fix here is not super complex. You need to know what leave laws apply to your business at your current headcount. Have a process, have someone who knows how to run it, because this is not a place where good intentions protect you. Mistake number 3, I said it's the most costly. That is misclassification. Here it is. This is the one that gets employers in trouble all the time. And it comes in 2 forms. Both of them carry significant financial exposure, and we have seen it over and over. The first is employee versus independent contractor. A lot of small businesses use contractors, sometimes for legitimate reasons, sometimes because it's cheaper and less complicated to have a contractor than an employee, right? The problem is that there is a legal test for whether someone is actually a contractor, and that has nothing to do with what you call them or what their contract says. It has to do with how the work relationship actually operates. Things like, do you control how they do the work, not just the output? Do they work exclusively for you, or do they have other clients? Do they use your equipment? Do they have a set schedule you determine? If the answer to those questions is yes, then you probably have an employee and not a contractor. And if that person has been treated as a contractor for 2 or 3 years, the back liability, unpaid employer taxes, benefits, overtime can be significant. The IRS and state labor agencies pursue this actively. We once did an audit with a client and found several contractors that should have been employees. We were having a really hard time convincing the CEO that this was a big deal. So on the next call with their employment attorney, we brought it up and asked the attorney what they thought. And here's their exact words. I want you to hear this. They said, if this is ever found out by the state, you will need to be ready to open your checkbook and write one hell of a check, because this is not an area they play about. The second form of misclassification is exempt versus non-exempt. So under the Fair Labor Standards Act, employees have to meet specific tests based on their salary and their actual job duties to be classified as exempt from overtime. A lot of small businesses classify people as salaried and assume that means no overtime obligation as long as they meet the salary threshold. But that's not how it works. If someone is classified as exempt but doesn't meet the duties test, what they're actually doing, you have to pay them overtime. And the back payment of that, if found out, could go back years. And that's on top of the penalties. This is the one I said costs the most because it almost always involves back pay across multiple employees over multiple years. A single misclassification audit can result in a liability number that is genuinely destabilizing for a small business. And then you are on their radar. Once they've done one audit, they will audit you every couple of years just to be sure you are still compliant. It only takes one pissed off employee to make a wage and hour claim and expose your entire business. Mistake number 4 is lesser known compliance requirements. This is the category where we often hear things like, I didn't even know that was a thing we had to do. I didn't know that was a requirement. We hear that more than anywhere else. And unfortunately, like good intentions earlier, ignorance is also not a defense in a legal situation. Every state has a set of required notices, disclosures, and documents that employers are obligated to provide, sometimes at hire, at termination, sometimes at other specific intervals. Most founders have never ever heard of most of them. California, where I am, is the most extreme version of this. And I use it as the example because it's where the requirements are definitely most specific and the enforcement is most active. In California, employers are required to provide a set of specific notices at the time of hire or termination. These aren't optional. They're mandatory, and they have to be the current version, which of course gets updated quite often. California also has the strictest final pay timing laws. If an employee is involuntarily terminated, final pay is due at the time of separation, same day, in that moment. And failure to comply triggers waiting time penalties that continue to accrue for up to 30 days. California is, as I said, the most extreme case, but every state has its own version of these requirements. Some of them may be different. There's probably specific notice obligations, final pay timing rules, overtime rules, required postings. Most small business owners discover them for the first time when they've already failed to follow them. The fix here is genuinely simple. Know what your state requires. Audit your onboarding and offboarding against those requirements and update them when the law changes. This is one of the lowest effort compliance wins available to a small business, and it's one of the most commonly missed. Oh, and if federal and state law differ, you always offer the most generous of whatever it is. Mistake number 5 is failing to investigate every complaint. This last one is the one with the longest tail. It's the one that I said ruins your reputation the most. When a complaint surfaces about harassment, about discrimination, about a hostile environment, about bullying, the founder's instinct sometimes is often to assess it informally. They talk to the people involved. They make a judgment call. If it seems like a misunderstanding or a personality conflict, they handle it as such. They may even brush things off because they know the offender didn't mean any harm or didn't mean anything by it, or because they think the complainant is too sensitive. These are actual words that have been said to me by leaders. In the eyes of employment law, the failure to conduct a proper investigation of a harassment or discrimination complaint is itself a legal exposure, separate from whatever the underlying conduct was. There's so many layers to these things. Here is what a proper investigation requires. First, it has to be prompt. It has to be thorough. It has to be conducted by someone who is neutral relative to the parties. It has to involve interviews of the relevant witnesses, and it has to be documented. The findings have to be documented. The actions taken in response have to be documented. The reason this matters so much legally is that employers have an affirmative action defense. So you actually have a defense available to you in things like harassment cases. But you can only use that if you show that you had a complaint procedure, the employee used it, and the employer responded appropriately. An informal conversation that resolved nothing and was never written down does not establish that affirmative action defense. There's also a retaliation dimension here that founders consistently underestimate. If an employee raises a complaint and then, even coincidentally, experiences a negative employment action shortly afterward, the timing becomes evidence of retaliation. A performance improvement plan issued 3 weeks after a harassment complaint. A schedule change that reduces hours shortly after a performance issue. A restructuring that eliminates someone's role. Timing matters in ways that most founders don't anticipate. Failing to investigate every single complaint doesn't just create exposure on the original claim, it often creates exposure on a retaliation claim that carries its own damages and its own legal weight. And then that makes news. With social media and neighborhood social sites popping up all over the country, the public will likely know that you are involved in a lawsuit. And the damage that that can do to your external reputation, it's massive. And that can take years for your business to recover from. So that's it. 5 mistakes. None of them require bad intentions. All of them are sitting in small businesses probably right now. They are accumulating exposure that will surface at some point. A thorough HR audit will help you identify if any of these sit in your business. We have one available on our website, an HR audit form, which we will link below, but always you should get some help and some expertise in handling that. You want to look at your documentation practices, your leave handling process, your worker classifications, your onboarding and offboarding documentation, and your complaint response procedure. Find the gaps before they find you. This is one of the areas where working with someone who has seen these issues across dozens of businesses at your stage makes a real difference, because you don't know what you don't know until someone who has seen it before walks through your business with you. For more on this topic and more just small business content, I would love for you to connect with me on LinkedIn. My LinkedIn profile is linked below, and you can just send me a note telling me how many employees you have in your organization. I would be happy to connect with you. Most founders build reactively. They focus on sales, marketing, and product, and they treat people as an afterthought until the people start costing them everything. A business where compliance is built before something breaks, where documentation exists before it's subpoenaed, where leave requests are handled with a process, not a phone call, where every complaint gets a written response. That is a business that scales. Let's build that.